Thank you very much. Is there a second to the motion?
Mr. Speaker, I'll second the motion.
It has been moved and seconded for amendment number 18. Discussion on this measure. Representative Oshiro.
Thank you very much, Mr. Speaker. Floor amendment number 18, footer 14-0232, adds a severability clause. It's similar to what was in House Bill 6. The purpose of a severability clause, Mr. Speaker, or inseverability clause, should I say, is to have the effect that if any part of this law or act is deemed unconstitutional, null and void, the entire act goes away. It's based upon an inseverability, non-severability clause, I believe in the state of New York, where that was enacted several years ago. The purpose and intention of having a non-severability provision is this. It calls both sides to debate and discussion to realize that each are equally responsible to maintain the integrity of the whole act, all the parts, and that neither should use any deficiency of the part to be challenged and deemed unconstitutional or null and void. And in a way, it kind of puts both parties into a standoff, should I say, Mr. Speaker, so that the live and let live values that we have in Hawaii will be able to continue going forward, and that we might never need to come back in to address this on a more substantive policy level. And that's been in place for several years now. So I put this before the body just to ensure that we can get some kind of assurances from both sides of this debate and discussion that neither will have their fringe elements seek to defeat the intent of this law as we attempt to balance both equal protection, due process, with fundamental religious freedoms and rights. Another provision in this is to make the rulemaking authority that we have been given to administer the licensing through the Department of Health, all the full measure and benefit of public involvement, participation, and transparency under Chapter 91. Again, Mr. Speaker, the current language in the bill seems to give them carte blanche authority to do any and all things in the process of implementing this law. I think it's a dangerous precedent. It may also be an unlawful delegation of authority to an agency without guidance. And for that reason, I think it should go by the normal Chapter 91 procedures of public participation, inspection, debate, discussion, and disclosure. I believe it also would run afoul, as currently drafted, of HRS 201M-2, the Small Business Impact Statement, which reads as follows. Prior to submitting proposed rules for adoption, amendment, or repeal under Section 91-3, the Hawaii Administrative Procedures Act, the agency shall determine whether the proposed rules affect small business, and if so, the availability and practicability of less restrictive alternatives that could be implemented. Mr. Speaker, the governor has the authority, and he has used it in the past in promulgating such rules as, I think, fishing regulations. So there is emergency rulemaking authority, or emergency rulemaking authority regarding the State Historic Preservation Division, so that can be done. But the foundational law should not give any agency or department unfettered discretion to promulgate rules in effectuating the law. Number 3, there is a divorce provision here that I believe others will speak to. I believe it's Section 10, that I believe unconstitutionally gives out-of-state litigants the ability to access our family courts and thereby annul or seek dissolution or even support orders through our family courts without having the requisite domiciliary requirements or residency requirements under current law. As a former family practitioner, Mr. Speaker, it was always impressed upon me that you needed to have both the rest and the property and the parties available in the jurisdiction which the family court sits. And finally, Mr. Speaker, an important element insofar as we are reflecting upon Connecticut state's law. And members need to understand that Connecticut state law is only of any support for the proposition of providing realistic support for the religious solemnizations or exemptions therein.
Mr. Speaker, Mr.
Yeah.
Speaker, to your right, may I yield my time, sir?
So ordered.
Thank you very much.
Speaker.
Thank you, Speaker Emeritus. And the reason why they has any of the authority or could have any of that is that in Connecticut, they have adopted a state's version of the Religious Freedom Restoration Act. And as I spoke before, that's an important component to have the state as a private cause of action, a policy established by law, of having the Schubert balancing test placed above all of its state agencies, administrating procedures, and their commission. When you have that conflict between religious freedoms and individual liberties, Connecticut has that provision on its books through its own Religious Freedom Restoration Act. And I think that insofar as we're looking at Connecticut's law, Mr. Speaker, it would be wise and prudent and consistent with the Connecticut law to also have that in what we're looking at today. And that's the purpose of my amendment this afternoon, Speaker. Thank you.
All right, thank you very much for the discussion on this item.
Mr. Speaker?
Yes, Representative Sharon,
Thank you. In support?
please proceed.
Thank you, Mr. Speaker. First, may I please have the words of the Speaker from Wahiwa entered into the journal as if they were my own?
So ordered.
Thank you, Mr. Speaker. Secondly, Mr. Speaker, I do have concerns about the section, and I did in fact mention this the night that we voted out Senate Bill 1, House Draft 1 from the Joint Committees on Finance and Judiciary. Specifically, again, this bill is entitled to Relating to Equal Rights, and when we talk about the divorce proceedings, we are essentially allowing couples now who are not domiciled here in the state of Hawaii to obtain a divorce in this jurisdiction if the jurisdiction in which they live does not provide for same-sex marriage. Mr. Speaker, again, if you understand divorce law, and I don't propound to be an expert. I actually have friends who have taught me over the past few days the problems. I've been consulting with my colleagues and some of my friends who contacted me about this section. They have grave concerns about this section, insofar that it does in fact violate current family court proceedings by allowing a divorce without providing for children of the marriage. It doesn't require the same jurisdictional requirements that it does for heterosexual couples. So for example, a heterosexual couple that wants to obtain a divorce in the state of Hawaii would be required to have at least one of those parties domiciled in the state of Hawaii for 6 months. In this situation, both parties do not have to be domiciled in the state of Hawaii. That is not equal, Mr. Speaker. Moreover, it creates many problems. Why is it now the state of Hawaii's responsibility, our taxpayers' responsibility, to go after and obtain jurisdiction, for our courts to obtain jurisdiction over two individuals who don't in fact live in our state? In addition, there's another problem with this section, Mr. Speaker. Let's assume that the same-sex couple is in fact separated, not legally, but physically separated. One is living in a state that does in fact have same-sex marriage, recognizes same-sex marriage, and one is in a state that doesn't recognize same-sex marriage. So does that now preclude forum shopping? So there continue to be many sections in this which are very problematic from a family law perspective. And again, Mr. Speaker, I am not an expert, but I've been contacted by the experts, and they are the ones urging me to support these floor amendments. Because will create several problems under family law if we pass this bill as is. For those reasons, Mr. Speaker, I support the floor amendment. Thank you.
Thank you very much, Representative, for the discussion. Remember, we have a 10-minute limit. Please proceed.
Thank you, Mr. Speaker. I rise in opposition. Let me make a number of points. These floor amendments have not had public review, have not had a committee hearing. Number two, these amendments have been produced outside the normal process. The normal review by attorneys has not been made because they have been dropped on our laps literally minutes ago. Number three, we have 29 amendments here, 29 floor amendments, perhaps more than ever before. Now, these 29 amendments have been dropped on us slowly, a couple at a time, a bunch at a time, strung out over days, and at the last moment. From my reading, some of these amendments which we have before us and some of these which we have just dealt with are identical or virtually identical to amendments we have considered on Wednesday. I mean, I have not compared them word for word, but in my very quick reading in the time I've had, it seems that there is some redundancy. So, what do? We have gotten some assurance that in terms of the technical aspects of this bill, we have a bill that is adequate and sound. Number two, we are not the last arbiters of this bill. This bill still has to go over to the Senate, and the Senate has at least 1 3-day weekend to look at these bills. I mean, these floor amendments.
Mr. Speaker, point of order.
State your point.
What the Senate does or doesn't do with this bill is not relevant.
So ordered. Thank you,
Okay.
Representative.
Well, I'm just trying to speak about the process.
Yes, Representative. But remember the time limits. We have 29.
Okay. Then the bill goes to the governor for further review and signature, another legal check. So there are opportunities to perhaps improve the bill if these floor amendments are worthy. And we, right now, can only do what we can in the time we have. Thank you.
Thank you very much,
Mr.
sir.
Speaker.
Mr. Speaker.
Yes,
Call for the
Representative.
question. A call for the
Question has been called.
Point of parliamentary
Question has
procedure.
been
Point of
called.
parliamentary information that supersedes his motion. Point of
State your-
parliamentary procedure.
State your point.
Mr. Speaker, where in the rules does it say we can only talk about 10 minutes? Where does it say we can only do 29 amendments?
rule
Because
is-
we've already done 18 of those.
It's the rules
The
of
gentleman
the
is
majority.
talking about 29 amendments. There are not 29
Mr.
amendments
Speaker.
to go.
Recess.
It's cooking the books.